Okay, friends, we have been discussing about test paper number 3. That is, in test paper number 3, there are 3 topics are there. One is the currency management of Reserve Bank of India, and then that is integrated ombudsman scheme of Reserve Bank of India, because the banking ombudsman underwent a change. So integrated the ombudsman scheme of RBI, which we already covered. Then we started with the nomination. So now quickly we will finish the nomination. First I will go through the slides, then we'll go to the question paper. Then test paper number 4 is also uploaded to you. That is, it's already posted in the group today morning. Test paper 4 consists of around 145 questions. It consists of mainly questions on legal aspects of banking, and then along with negotiable instrument acts. So questions are, that is definitely very much possible for clerical to officer. Why I am telling is 200 questions are there. So questions are definitely possible coming from these topics, whatever we have covered. I think Mr. Ravi Kumar has covered 2-3 topics. He'll be joining with us next week. He's busy with some other program. He'll be joining us with next week. So that is these things again and again till 23rd. If you read, show short of getting some good marks in the examination. Okay. So I will quickly go through the nomination. So I already started with the nomination. So nomination is available in the bank. So nomination is available for various facilities. Now we are going to discuss nomination with regard to banking. Nomination is available in the bank for deposit accounts. Then it is available for locker. It is available for safe custody of articles. Recently in our bank last year, nomination is available for gold loan also. So why nomination? Why we insist on nomination? The bank is also conducting the nomination week or nomination fortnight, etc. Why nomination is insisted upon? Because whenever there is a nomination, it is very easy to settle the death claim instead of settling the death claim to legal hands. Settling nomination is very that is easy, and it is not a cumbersome process. So bank is insisting upon nomination. So now we will quickly go through. Nomination is available for accounts in the names of individuals and also for proprietorship firm. Okay, for no other accounts, nomination is available, whether it is a locker or deposit or safe custody article. So nomination is available only if it is in the name of an individual. If it is in the name of a single individual or joint individual, nomination is available. So in the case of a locker, whether it is a single individual or not joint accounts, nomination is available. But in the case of a safe custody article, if the safe custody article is deposited by a single individual only, nomination is available. If it is deposited jointly, it is not available. So proprietorship accounts also nomination is available. Gold loans are also nomination is available. Okay. Then, so accounts in representative capacity other than proprietorship accounts not eligible for nomination. You already know. Minor account represented by guardian is eligible for nomination. So in the nomination form, guardian has to sign. But minors account operated by themselves, that is minors cannot nominate for their accounts. Minors cannot nominate for their self-operated accounts. I already told you about these sections, you should know. So deposit, nomination, registration is section 45ZA and settlement is 45ZB. Safe custody article 45ZC, 45ZC. See A, B, C, D, E, F. Locker 45ZE, 45ZF. If they ask in the exam, so which is section 45ZA relates to? Nomination, deposit, registration, nomination, deposit, settlement, safe custody, settlement, like that. So you should know this 6 sections. Then, so in the case of a deposit, whether in a single name, joint name, proprietorship, nomination is permitted. The nominee will be only a single individual. In the case of a safe custody article, so if it is deposited in single name only, nomination is permitted. Then proprietorship account also, nomination is permitted. The nominee will be only a single individual. In the case of a locker, whether single locker or joint locker or locker in the name of a proprietorship, locker operation either or survivor. In the case of a joint, nomination is permitted. The number of nominee will be only a single individual. However, locker in the name of joint individuals, operation condition jointly, then in that case there will be more than one individual. Maximum 2 individuals can be the nominees. Please note it down. Everywhere if you see the number of nominees in the locker is only one. Number of, we are talking about nomination with regard to banking scenario. We are not seeing, we already saw in the case of a public provident fund, etc., maximum nominees will be 4. We saw in the that is sovereign gold bond, number of nominees can be 2, like that we saw. Capital gains account, we saw number of nominees will be 3. So here we are seeing the nomination with regard to the bank deposit. So in the case of a deposit or safe custody or locker, when they are like this, so there will be single nominee. But in the case of a locker operated jointly, the nominee will be again individuals, but more than one individual is permitted. Maximum number of nominees will be 2. So note it down, because when the settlement of the nomination claim comes, there is going to be a difference between deposit settlement and locker nomination settlement. Okay, this is the thing. Then quickly we will go through. So these things you should know by number. So once they ask for clerical to officer, what is the form number for cancellation of nomination for deposit account? So it is NF 144. Okay, so like this is given. This you have to go through only, no other option. Then overall can nominate, who cannot nominate, further things we are going to see. An insolvent person, insane person cannot nominate, but they can be nominees. Similarly, a minor cannot nominate, but a minor can be a nominee. A proprietorship account can nominate, but a proprietorship account cannot be a nominee. Again, I repeat, an insolvent person cannot nominate, but he can be a nominee. A minor cannot nominate, but he can be a nominee. A proprietorship account can nominate, but it cannot be a nominee. Okay, sir. So in the case of a Reserve Bank of India guidelines, if the account is in the name of a single individual, you have to insist on nomination. Nomination is compulsory in single named accounts. Witness this question they ask. Suppose in the nomination form, the deposit account opening form itself in the bank, nomination is available. DA1. So if the depositor is a literate person, then against the nomination registration, you are having 2 witnesses column. If the depositor is a literate, then there is no need for witness. If the depositor is illiterate, then you have to get 2 witnesses. Witnesses for nomination is needed for illiterate deposit account or illiterate locker account or illiterate safe custody article account. So if they are literate, then you need not get any witness. This question frequently they are asking. Then in the deposit receipt or in the passbook, so the word, whenever there is a nomination is registered, the word nomination registered has to necessarily come. Whether the name of the nominee to come or not, that is at the discretion of the depositor. If the depositor asks for the name of the nominee to be printed only, you have to print. By default, you should not print the name of the nominee in the passbook or in the deposit receipt. Only nomination registered word should come. If they ask for the name of the nominee to be printed, then you have to change the drop-down menu. Accordingly, you have to print. Name of the nominee to be printed, name of the nominee to be printed only at the request of the account holder. Then nominee to be an individual only. HUF cannot be a nominee. Company, firm, trust, proprietorship, etc. cannot be nominees. Nominee can be a minor. Nominee can be an insolvent. Whenever a minor is a nominee to account, or whenever an insolvent person is nominee to account, another person to be appointed by the account holder to receive the money if something happens to the depositor when the nominee continues to be a minor or when the nominee continues to be an insolvent person. Nominee can be a minor, nominee can be an insolvent person to receive the money to be indicated. All of you know. All account holders have to sign the nomination form. So whenever there is a nomination, so the nomination once made, it is not necessary only at the time of account opening nomination to be made. Subsequently also nomination can be made. So so similarly, any number of times nomination can be cancelled. Any number of times nomination can be changed. Whenever it is done, if there is a single depositor, he only will sign all these forms. I told you, I given the form numbers in the second slide. So whenever there are more than one depositor, any nomination, change, alteration, all depositors have to sign the nomination or cancellation or alteration form. Nomination can be cancelled, varied any number of times with the consent of all account holders. So they are asking this question, again a different color. Nominees are what? Nominees are the trustees of legal heir. Nominees are the trustees of legal heir. You should know the meaning. So let us assume you are getting 70 marks and you are going for interview. In the interview committee, somebody asks you, nominees are the trustees for legal heirs. What do you mean by that? See, that means when a depositor is there, even though legal heirs are there for him, he nominates somebody. So the nominee need not be the blood relative. The nominee need not be a relative. He can be any person. Okay, he nominates a person. Once he nominates a person, it is a duty of the bank to give the money only to the nominee until otherwise there are certain circumstances where you have to give to the legal heir. That we will see in the last. So what do you mean by nominees or the trustees of the legal heirs? When bank is settling the money and giving to the nominee is receiving the money. He is receiving the money on behalf of the legal heirs. That is called nominees or the trustees for the legal heir. Suppose on a later date, if there is a dispute between the legal heirs and the nominee, there is no responsibility on the part of the bank, then legal heir will go to the court. Court may ask the nominee to give the money back to the legal heirs. So bank is not responsible in any such matter. Nominees or the trustees of the legal heir means nominees are receiving the money on behalf of the legal heirs of the deceased customer. Okay, sir. Then nominees are single individual. Again, I am telling only in the case of a locker operation jointly, the nominee can be more than one individual. Maximum it can be two. Nominees not to sign the nomination form. So there is no, at the time of making nomination, we cannot ask for the nominee's signature in the account opening form or nominee signature in the nomination form. We will not ask the KYC document of the nominee, etc. We will ask name of the nominee, address, relationship with the depositor. If it is a minor or insolvent person, another person should be appointed to receive the money. That's what we will ask. Nominees need not sign in the nomination form. KYC document of the nominees need not be obtained at the time of registration of nomination. When settling the nomination, you have to get. Okay, sir. Illiterates can nominate and can be nominees also. Again, I repeat. A minor, that is, cannot appoint nominee, but he can be a nominee. An insolvent person cannot appoint nominee, but he can be a nominee. A proprietorship firm can, that is, make nomination, but a proprietorship firm cannot be a nominee. Coming to illiterates, illiterates can nominate and they can be nominees also. Illiterates can nominate and they can be nominees also. Nominee can be any individual. They need not be relatives to the account holder. In joint deposit accounts, now very, very important. I told you in the case of a joint deposit account, so nominee will be a single individual. In the case of a safe custody article, only if it is deposited by a single individual, you will permit nomination. The nominee again will be a single individual. In the case of a locker, either single or joint, if either are survivor operation condition, then there will be only single nominee. In the case of a locker operation jointly, there can be more than one individual as a nominee, and in maximum it is two. Now, now here I am going to show you, see in the case, see for example, let us assume there is only a single depositor to your KDR. There is one nomination. If the depositor dies, you will give the money to the nominee. So in the case of a locker, there is single locker operator, there is a nominee. If the locker operator dies, you will give the money to the nominee. But in the case of a deposit account, operation jointly. In the case of a deposit account, the joint deposit operation can be either or survivor or jointly, whatever it is. In the case of a joint deposit account, A and B. Okay, so A and B, either or survivor, A and B jointly, or A and B farmer or survivor, whatever it is. In the case of a joint deposit account, if there is a nomination for a joint deposit account, if one of the depositor dies, the nominee will not enter into picture. Please note it down. In the case of a joint deposit, whatever may be the operation condition, if one of the depositor dies, the nominee will not enter into picture. Nominee's right arises upon the death of all the depositors, whatever may be the operation condition. That is, so that is what keep in mind. Then branches, what is the power of a branch to settle nomination? You know, that is in the case of a death claim, branch managers and senior managers are having power up to 2 lakhs. Then chief manager AGM is having some powers, RO is having some powers, etc. Isn't it? But coming to, and you also know in the case of locker, that is safe deposit locker or safe custody articles, branches do not have power to settle death claim. That is with regard to death claim where there is no nomination. Wherever there is nomination, whether the branch is headed by a scale 1 manager or scale 2, scale 3, scale 4, scale 5, whatever it is, where whenever there is a nomination, either for a deposit account or either for a locker account or either for a safe custody article or either for a gold loan, the full power is with the branches. Branches only how to settle. It need not be referred to anybody else until otherwise you have some confusion. Okay, branches to settle nomination irrespective of the amount, as well as safe deposit article, and also in respect of lockers and gold loan. They have full powers, no question of power for nomination. The death claim only is having some powers. Okay, sir. So 2 points I told you here. In joint deposit accounts, nominee right arises upon the death of all depositors. Joint deposit, whatever may be the operation condition. Okay, coming to locker. In joint locker accounts, operation jointly, nominee can be more than one individual. I already told you. Okay, sir. So next point you see, in locker with operation condition jointly, nominee right arises upon the death of one of the joint hirers. Again, I repeat, in the case of a deposit account, joint deposit, whatever may be the operation condition, that is nominee's right arises upon the death of all the depositors. Okay. In the case of a locker, if it is either or survivor operation, nominee's right arises upon the death of both locker hirers. Like deposit. Deposit, joint deposit, if it is either or survivor, if one depositor dies, nominee right will not arise. Deposit, operation jointly. If one depositor dies, nominee will not enter into picture. Coming to locker. If locker operation is either or survivor, one locker hirer dies, nominee will not enter into picture like deposit. On the other hand, in the case of a locker operation jointly, in the case, again I repeat, please hear it. In the case of locker operation jointly, nominee right arises upon the death of one of the locker hirers. That is the difference between joint deposit operation jointly and locker operation jointly. In the case of a joint deposit operation jointly, so if one of the depositor dies, nominee will not enter into picture. Coming to locker, if in the case of a locker operation jointly, if one of the locker hirer dies, nominee will enter into picture. That is a difference over there in settlement of nomination. See? In locker, with operation condition jointly, nominee right arises upon the death of one of the joint hirers. Example, if locker is the name of A and B, operation jointly, nomination is given in favor of Mr. X and Mr. Y. I told you, in the case of a joint operation locker, there can be more than one individual as a nominee. There can be one individual or there can be more than one individual, maximum 2 individuals. So locker operation A and B jointly, nominees are Mr. X and Mr. Y. Here what happens? Mr. A dies. Mr. A dies. So when A dies, one of the locker hirer dies. So when A dies, the contents to be vacated and given to Mr. B. Who is Mr. B? The surviving locker hirer. You have to give to Mr. B and along with whom? And both the nominees, Mr. X and Mr. Y. If there is only one nominee, you will give to that nominee along with the surviving locker hirer. Legal heirs of A does not enter into picture. See, again I repeat, so locker operation jointly, if one of the locker hirer dies, then you will vacate the locker and give it to surviving locker hirer along with the nominees. Coming to deposit, you see the next slide. See, if deposit payable jointly, suppose instead of locker here, let us assume deposit payable jointly A and B. So there can be only one nomination. Let us assume one Mr. X is the nominee. If one of the depositor dies, what is operation condition? Payable jointly. If one of the depositor dies, to whom you will give the money when there is a nomination? In the case of a joint deposit, nominee right arises upon the death of both the depositors only. So if it is instead of locker, if A and B are having a deposit with you, and if there is a nomination, Mr. X, because for deposit there can be only one nominee. Let us assume there is one Mr. X is the nominee, one Mr. B dies, then to whom you will give the money? The operation is jointly, that is deposit account I am telling. Then you will give settlement of death claim in favor of A and the legal heirs of B. But here, in the case of a locker, what you do, you are not taken the legal heirs of A. You are given the content to Mr. That is A, that is Mr. B, who is the surviving locker heir, and Mr. X and Y. If it is deposit payable jointly, only if A and Mr. B dies, nominee will enter into picture. If A only dies, settle to B and legal heirs of A, since it is payable jointly. So friends, difference between settlement of nomination, deposit account payable jointly, locker account operation jointly. This is the difference. Okay, then which are all the documents for settlement of nomination? Death certificate, claim form NF 147 signed by the nominee, to be attested by magistrate, officer of central or state government or bank or two well-known persons acceptable to the bank. Proof of identification of nominee like Aadhaar, driving license, passport, etc. So you will ask the KYC documents of the nominee only at the same time of settlement. So the form number for settlement of nomination is NF 147. So nomination settlement is very simple. Okay, it's very simple. Get the death certificate, get NF 147 signed by the because signed by the nominee, then it has to be attested by somebody, then proof of identification of the nominee you get and settle the nomination. Coming to, so stamped receipt to be obtained irrespective of the amount. Stamped receipt from the nominee to be obtained irrespective of the amount. You see here, suppose there is a nomination to the account. When the legal heir and the nominee approaches the bank, claim to be settled in favor of the nominee only, because nominees are called the trustees for the legal heirs. Okay, when the legal heir and the nominee approaches the bank, if there is a nomination, settle in favor of the nominee. Suppose if the legal heirs are bringing a succession certificate, so if the legal heirs are bringing a, so there is, let's assume there is a nomination, but the legal heirs are coming, they are bringing a succession certificate, or they are bringing a probate. Okay, or if there is a court order restraining the bank from making the payment to the nominee, bank has to abide by the succession certificate, probate, or court order. So what do you mean by succession certificate? See, you know, from whom you will get the legal heir certificate? Generally, we will get the legal heir certificate from the Tahsildar or revenue officials of the area, isn't it? But what is the succession certificate? The succession certificate is also called the legal heir certificate. Who issues the succession certificate? The district court, I court, they issue the succession certificate. The succession certificate is also a legal heir certificate issued by the court authorities. If the legal heirs are bringing a succession certificate, that is, it is certified and issued by the court. So even though there is nomination, you have to give the money to the legal heirs only. Second point, if the legal heirs are bringing a probate, what do you mean by a probate? When a person, before his death, he writes a will. He writes a will and the will is certified by the court. It is called probate. So before a person dies, he writes a will. So I have a deposit with Canara Bank. So after my death, the money should go to this person. Okay, so he writes in the will, the deposit in Canara Bank should go to Mr. X. But in Canara Bank, he has given somebody as the nominee. Somebody as the nominee. So if a person brings the probate, probate is a will certified by the court. In that case, even though there is nomination, you have to give the money to the probate holder only. And third point, if there is a court order, If the court issues an order restricting the bank not to pay the money to the nominee, then also you should not pay the money to the nominee. In these three circumstances, even though nomination is there, banks are prohibited to pay the money to the nominee. So suppose before these people come, if the nominee comes, you can settle it, no problem. Because nominees are the trustees for the legal heirs. Before these people come, if the nominee comes, you settle, no issue. But if somebody brings these things, when there is a nomination, you have to settle only in favor of these people. Okay, sir. Then, so this is what we saw is with regard to settlement of nomination. Whenever there is a nomination, when there is no nomination, what is the procedure in the bank? So certain form numbers I will tell, note it down, then we'll quickly finish the question paper. So death claim. So nomination is different, death claim is different. So for how many years we have to preserve the death claim form, sir? The death claim register or the nomination form, nomination register or death claim forms, death claim application, death claim file, we have to preserve permanently. If they ask that question, don't leave it. We have to preserve them permanently. Claim amount up to 10,000, death claim we are talking. Claim amount up to 10,000. So what is the form number? So you have to get the death certificate. Then appendix 2 of the manual of instruction on death claim. So as per appendix 2, you have to take claim amount more than 10,000 up to 50,000. You have to take appendix 3 of manual on death claim on nomination updated till 31/3/2020. Appendix 2 is for death claim up to 10,000. Appendix 3 for death claim more than 10,000 up to 50,000. Here I am talking about death claim without nomination. Then if the claim amount is more than 50,000, you have to get enough 1020 with annexures. If the claim amount is if the claim amount is more than 50,000, you have to get enough 1020 with annexures. If they ask the form number, you should know enough 1020. Then this is the power for settling the death claim without a nomination. I told you for nomination, sky is the limit. So whenever there is a nomination, irrespective of the deposit amount, the branch in charges can settle. For locker, they can settle. Safe custody article, they can settle. Gold loan, they can settle. So coming to death claim, so when there is no nomination, settlement of death claim to the legal heirs, it is the power. If they ask you the power, you should be able to write. Managers, senior managers in charge of branches, 2 lakh. Scale 4, that is divisional manager heading the chief manager heading the branch, 3 lakhs. Scale 4 in ROs, that is divisional managers in regional offices and AGMs heading branches, it is 5 lakhs. There is AGMs in regional offices, it is 10 lakhs. Deputy general manager, whether he is heading a regional office, whether he is in circle office, whether he is heading a large corporate branch, the DGMs are having full powers. So they can settle, see there is locker, they can settle safe deposit article, and they can settle the nomination in the death claim amount irrespective of the full amount, full power. Locker, safe custody article, DGM is having the power. Scale 4 and 5 heading the branches, and if they are leave, and the leave is beyond 7 days, whether managers, senior managers can sanction. So scale 4 and 5 heading branches, suppose the DM is chief manager is heading a branch or AGM is heading a branch, there is a death claim, they are on leave beyond 7 days, then the manager or senior manager heading the branch can sanction the settle the death claim provided the amount is up to 2 lakhs. You see, scale managers and senior managers 2 lakhs. See scale 4 heading branches is 3 lakhs. Even though the scale 4 power is 3 lakhs, if it's beyond 7 days on leave, the senior manager can settle if it is up to 2 lakhs only. Okay, sir. This is the death claim and nomination. So any doubt is there, you can post me in WhatsApp. Quickly, we'll go through the question paper now. Okay. So we are now seeing that is section. So various sections I told you, that is this is nomination and death claim. This test paper number 3. We are now doing question number 39. Section 45 ZC on the Banking Regulation Act 1949 refers to. Answer for the question is C. That is, there is a C, registration of nomination for safe custody article. So if you read this question, I told you 45 is A, 45 is B, 45 is C, 45 is D, like that E and F we have finished. So 45 ZD stands for registration of nomination in safe custody article. Question number 39, answer is C. Okay, so they will give, for example, if the question is like this, let's assume in a different manner. Registration of nomination safe custody article is defined under which section of Banking Regulation Act? Then you have to write 45 ZC. That is why I told you the 6 sections you should be thorough. Okay, question number 39, answer is C. Question number 40. What is the form number for registration of nomination under capital gains account? Answer is NF733. It is also given in the PowerPoint. NF733. Then, can an insolvent person be nominee? Yes, he can be a nominee, but he cannot nominate. Can an insolvent person be nominee? Yes, he can be the nominee, but he cannot nominate. Similarly, a minor can be a nominee, but minor cannot nominate. A proprietorship firm can nominate, but a proprietorship firm cannot be a nominee. Illiterates can nominate, and they can be nominees also. Question number 41, can insolvent person be nominee? Yes, he can be nominee. The legal status of the nominee is as that of trustees of legal heirs. I told you, trustees of legal heir. Question number 43. Whether a proprietorship firm can be a nominee for a deposit account? No, they can only nominate. So whether a proprietorship firm can be a nominee for a deposit account? No, proprietorship account can only nominate because nominees will be only individuals. Proprietorship firm cannot nominate. Question number 43, no. Question number 44, please read the question. Let us discuss. There is a joint SB account in the name of A and B operation jointly. Okay, both have to operate the account. They nominated X for this account. Okay, a deposit account, even though it is a single account or joint account, there can be only one nominee. There is a joint SB account in the name of A and B, operation jointly. They nominated X for this account. When A dies, to whom the money to be given? So, even though there is a nomination, I told you, in the case of a deposit account, nominee's right arises upon the death of both the depositors. So then whom you will give the money? You will not give the money to nominee. Then whom you will give the money? It is operation jointly. If it is operation jointly, you have to give the money to the surviving depositor along with the legal heirs of the deceased depositor. When A dies, to whom the money to be given? Question number 45, answer is A. So, sorry, question number 44. Question number 44. So, when they nominated X, when A dies, to whom the money to be given? A, option B, X to be given, C, legal heirs, D, B and legal heir of A. So question number 44, answer is D. So it is a joint account, operation jointly. Upon the death of one of the depositors, even though nomination is there, nominee will not enter into picture. You will give the money to the surviving depositor along with the legal heirs of the deceased depositor. Question number 44, answer is D. Question number 45. There is a joint SB account in the name of A and B, operation severally with a survivorship clause. So what do you mean by that, sir? So normally, so that is in the case of a either or survivor account. Either or survivor account, there are two that you have a running account and that is term deposit account. So you have a running account, you have a term deposit account. In the case of a running account, either or survivor, the operation condition is severally. Severally means any one of them can operate. In the case of a fixed deposit, if it is either or survivor, on maturity, the proceeds can be given to any one of them. So keep that in mind. So what do you mean by either or survivor for an that is a running account, SB account? It is operation is severally. Anyone can operate. So in the case of a deposit account, either or survivor condition, deposit account, either or survivor condition, term deposit, money can be paid to any one of them on maturity. Here the question is, so now in the case of either or survivor, in the case of either or survivor, operation is severally, let's assume, we are having an SB account in the name of A and B. It is either or survivor, operation is severally. If one depositor dies, A dies, what you are doing, sir? Normally in the branch, whether nomination is there, nominee will not enter into picture. Deposit in the name of A and B, A dies. So nomination is there, nominee's right arises upon the death of both the depositors. So either what you will do, A and B is the either or SB deposit, you will delete A's name and permit B to operate the account. How you are permitting it, sir? How you are permitting? Not because of the condition it is either or survivor. Because in the account opening form, if you see, there is a clause called survivorship clause. What is that survivorship clause? The survivorship clause says B, A and B made the deposit by both of us. We made the deposit. The operation condition is severally, that is any one of us can operate. In case of death of any one of us, bank has the right to give the money to the survivor without the legal heirs of the deceased depositor. That is called a survivorship clause. So again, I repeat, you are having an SB account in the name of A and B. It is either or survivor account. That means operation is severally. When one of the depositor dies, you are getting a death certificate, release the name of the deceased depositor, and permitting the surviving depositor to operate the account. This is based on what? It is based on the survivorship clause available in the account opening form. Because of that only banks are doing. If the account holder at the time of opening does not want the survivorship clause, so in the case of either or survivor also, if one of the person dies, you have to give the money to the survivor along with the legal heirs of the deceased depositor only. If there is a survivorship clause, in the case of either or survivor, you will give to the survivor without the legal heir. Okay, sir, I explained to you now what is survivorship clause. So now let us see the question. There is a joint SB account in the name of A and B, operation severally with the survivorship clause. That means what? We can give the money to any one of them when one fellow dies. They nominated X for this account. X will not enter into picture until both A and B dies. When A dies, to whom the money to be given? So the money to be given to B, because it is either or survivor, operation severally, there is survivorship clause. When A dies, you give the money to the survivor, who is Mr. B. So question number 45, answer is A. Question number 45, answer is A. Question number 46, let's come here. A joint locker in the name of A and B. Operation is what? Jointly. So B dies. Nomination in favor of C, to whom the locker access to be given. I told you, in the case of a locker account operation jointly, if there is a nomination, upon the death of one of the locker hirers, the locker contents to be vacated and given to the surviving locker hirer along with the nominee or nominees. So joint locker in the name of A and B, operation jointly, B dies. Nomination in favor of C, to whom the locker access to be given. So surviving locker hirer is A, and C is the nominee to A and C. So question number 46, answer is D. Question number 46, answer is D. Now similarly, we'll come there. Joint locker in the name of A and B. Joint locker in the name of A and B. Operation is severally. So here operation jointly. When operation is jointly, when one locker hirer dies, you will give the nominee, you will give then there is a nomination, survivor along with the nominee. But here joint locker in the name of A and B, operation is severally with the survivorship clause. What do you mean by survivorship clause? When locker agreement, if you see, there will be a survivorship clause. What do you mean by that? In the event of death of one of us, bank has the right to vacate and give the content to the survivor. That is survivorship clause. Okay. Joint locker in the name of A and B, operation severally with survivorship clause. B dies. Nomination in favor of C. If the locker is operated severally, then in that case, nominee's right arises upon the death of both the locker hirers. On the other hand, question number 46, if the locker is operated jointly, nominee right arises upon the death of any one of the locker hirer. Here, it is operation severally with the survivorship clause, there is nomination. So you don't worry about the nominee. Then to whom you will give? There is one locker hire dies. Since there is a survivorship clause, you vacate the locker contents and give to the survivor only. Okay, so who dies here, sir? B dies. So to whom the contents to be vacated and given? Question number 47, answer is A. Question number 47, your answer is A. Question number 47, answer is A. Then question number 48. A term deposit account, you please read the question very thoroughly. A term deposit account with repayment condition either or survivor. What do you mean by term deposit repayment condition either or survivor? On maturity, with regard to term deposit, the condition jointly or either or survivor is applicable on maturity of the deposit only. Okay, sir. The term deposit account repayment condition either or survivor. Deposit in the name of X and Y without the survivorship clause for 2 years. There is no survivorship clause. Okay, sir. It is either or survivor, but there is no survivorship clause. In the account opening form, there is no survivorship clause. X dies after 1 year of opening the deposit. Z approaches the bank for payment of deposit before maturity to him. Nominee is Mrs. X, to whom the payment to be made. You see the thing? Deposit is in the name of X and Y. Mrs. X is the nominee for the deposit. It is made for 2 years. There is no survivorship clause in the account. There is no survivorship clause in the account. So one of the depositor dies before the completion of the deposit. Then to whom you will give the money. So when there is no, if it is survivorship clause, you will give the money to the survivor. If since there is no survivorship clause, then it is a deposit account, the money to be given to the surviving depositor along with the legal heirs of the deceased depositor. So question number 48, answer is B. So survivor is Z along with the legal heirs of X. Why you are doing it in the either or survivor? Because it does not contain survivorship clause. So this is very, very, very important. Survivorship clause is very important, whether to make it to one person or make it to the legal heirs of the deceased person along with the survivor. Even though it is either or survivor, it depends upon the availability of the survivorship clause in your deposit account opening form. So question number 48, answer is D. Question number 49. Death claim to be settled within, this question they are asking. Death claim to be settled within dash days after submission of all claim papers by the claimant within 15 days. Question number 49, answer is B. Question number 49, answer is B. Question number 50. Settlement of death claim based on the succession law by which the deceased was governed is called. So what do you mean by that, sir? Settlement of death claim based on the succession law by which the deceased was governed. See, whenever a person, when he is alive, if he writes a will and after his death, we will give the settlement in favor of the persons named in the will, isn't it? Suppose if there is no will, if there is no will and there is no nomination, there is no will or there is no nomination, in that case, to whom you will give the money? Upon the death of the depositor, when there is no will or when there is no nomination, you will give to the legal heirs. So who are all the legal heirs for the deceased depositor? So, and how much share each person will get? That depends upon the succession law to which the deceased person belongs to. What do you mean by the succession law? See, the religion to which he belongs to. So he may be an Hindu or he may be a Muslim or he may be a Christian. So after the death, to whom the money should go and what should be the each share each individual should get. That is called the succession law by which the deceased was governed. So settlement of death claim, so we are based on the succession law by which the deceased was governed is called intestate disposition. It is called intestate. So testate means T-E-S-T-A-T-E. Testate means will. Intestate means without will. Intestate disposition. Disposition means disposing of. See, the settlement of death claim based on the succession law by which the deceased was governed is called intestate disposition. Okay. Suppose question number 51. If there is a will, settlement of death claim based on the will of the deceased is called. So question number 51. So settlement of the death claim based on the will of the deceased is called testamentary disposition. So testamentary means based on the will. What do you mean by testate? Will. Intestate means without will. Testamentary disposition means based on the will. Settlement of death claim based on the will of the deceased is called testamentary disposition. Testamentary disposition. Question number 52. These are all the one-word questions. Half marks you will get. Don't miss it. Question number 52. What is the power of a manager, senior manager in a branch headed by scale 4 or scale 5 when in the absence of the branch in charge is beyond 7 days for settlement of death claim? So the answer is for managers and senior manager, it is rupees 2 lakhs only. Question number 52, answer is D. It is already shown in the PowerPoint to you. Question number 52, answer is D. NSCs are pledged to overdraft. The face value is 2 lakhs. The market value is 2.50 lakhs. To determine the delegation of settlement of death claim, which one to be taken? Here, I will explain to you. So delegation for death settlement of death claim, when it will come without nomination, isn't it? Okay. 2 lakhs, 3 lakhs, 5 lakhs visa. It's without nomination. Suppose if there is a deposit, on the date of settlement of death claim, you have to see under that custody, what are all the deposits available or locker is available. You have to see in the system first. So death claim settlement is as per custody wise, it is not individual wise. Keep that in mind. Okay. If the power comes within you, you can settle 2 lakhs. Branch manager, senior manager power is 2 lakhs. Suppose if it is gold ornament, how, so let's assume the customer is not having any account with you, or SB is having 100 rupees balance he is having. So he has pledged a gold loan with you, you have to settle the death claim. There is no nomination. Nomination means you will give to the nominee. So there is no power. So you have to settle the death claim. So at the time of he pledging the gold, the value of the gold, let's assume he has given you some 10 sovereigns of gold. At the time of pledging the gold, the value may be 2 lakhs or 1.5 lakhs. Today, the gold value may be 5 lakhs. So based on what the, the power for settlement of death claim arises for deposit, total deposits available, including interest on the date of settlement. In the case of a gold loan, the appraised value given in the gold loan application by the appraiser, not today's market value. In the case of gold loan, how we will settle the death claim? Death claim means without nomination. Based on whose power you will decide. So in the case of a gold loan, it is the appraised value given in the gold loan application on the date of giving the loan by the gold loan appraiser. On that date, if he has mentioned 1.5 lakhs, branch power is 2 lakhs, you can settle. It is not the market value. On the other hand, that is banks take NSC, National Savings Certificate, and they give loan. Okay, so the face value of the National Savings Certificate may be 2 lakhs. On the face of it, it is mentioned 2 lakhs. It is for 7 years or 6 years, whatever it is. Every year, interest will be credited to the account by the post office, like your Kamadena deposit. If you are settling, that is, you are given an OD to the borrower. So now you have to settle the death claim. You have to settle, that is, get the proceeds, and you have to adjust to the OD, give the balance to the customer. So at that time, how the power is determined? The power is determined based on that day, the accumulated value, the market value. For gold loan, it is appraised value. For deposits, on the date of settlement, along with the interest of that, all the deposits of the customer. In the case of NSE, it is on the market value. So 2.5 lakhs. Okay. So question number is B. Question number 53, answer is B. Question number 54. Claims in respect of deposit accounts, up to what amount claim can be settled without a death certificate? See, you need not always insist for death certificate. In some cases, without death certificate also, you can settle the death claim. I'm talking about death claim without nomination. Answer is up to rupees 50,000. So claims in respect of deposit accounts, up to what amount claim can be settled without the death certificate? So answer is up to rupees 50,000. Answer is B. You need not insist on the death certificate. These things are available in your death claim manual. Then what is the form number of death claim settlement beyond 50,000? I told you it is NF1020. Question number 55, answer is NF1020. Claims up to rupees can be made to one or more claimants without insisting on the signature of all the claimants up to 10,000 rupees. Question number 56, answer is up to 10,000 rupees. Question number 57, surety to join the letter of indemnity in the case of a death claim if the amount is rupees 5 lakhs and above. See friends, I will tell you, we are talking about death claim settlement amount is that is 5 lakhs and above. Besides the claimants, two sureties to join. How many sureties are? If it is 5 lakhs and above, two sureties to join in the death claim form. So, however, the branch manager has the discretion to waive one surety. At least one surety normally, if the death claim amount is 5 lakhs and above, two sureties to join at the time of settlement of death claim. So, however, the branch manager can recommend for waiver of one, that is surety. Okay, surety to join the letter of indemnity in death claim if the amount is rupees 5 lakhs and above. Okay, question number 58. Claim papers to be preserved for permanently. Question number 58, answer is permanently. HO circular 166 bar 2021. Claim papers and files are to be preserved for very permanently. 166 bar 2021. Will certified by the court. What I told you, somewhere I told you about that word, before a person dies, he writes a will. The will is got certified by the court. It is called probate. 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 Will certified by the court is called probate. Question number 60. Claim settlement of missing person is covered under which act? This they are again and again asking. Who is a missing person? A person is not dead. He disappeared. Suddenly he disappeared one day. Then how he is having a deposit with you? Somebody is coming and telling, sir, that fellow is missing. Give me the money. There is no death certificate. There's no death certificate. Okay. So give the money. Nominee comes and asks you, sir, give the money. That fellow is missing. So when he is called as a missing person, a person is missing today, then from the date of lodging the FIR, that is first information report with the police authorities, the other people, the legal hands or the nominee has to approach the court. Court will give a certificate, declare him as missing person, provided the period of missing is 7 years and beyond 7 years from the date of FIR. From the date of FIR, so that is first when a person is missing, an FIR to be lodged. Then court will call him, declare him and give him a certificate like death certificate. Court will give a certificate that he is missing, provided he is missing for 7 years and beyond. Please note it down, from the date of FIR. So they will bring that certificate based on the death claim to be settled. Okay, different authorities having the power. Okay, so claim settlement of missing, the question is, claim settlement of missing person is covered under which act? It is covered under Indian Evidence Act. Please note it down. Claim settlement of missing person is covered under which act? Indian Evidence Act. I told you who is a missing person. So that question also will be asked in the exam. So don't think that only the questions given here are asked, the PowerPoint presentation and your knowledge, your discussion with your colleagues or other senior faculties taking classes, and then what I am telling in between, all those things, if you give value to it, if you read it thoroughly, you're sure short of getting 65-70 marks. Okay. Claim settlement of missing persons is covered under Indian Evidence Act. Verse number 61. Whether the branch headed by scale 2 can settle nomination under safe deposit locker? No, it has to be settled by CO. No, it has to be settled by RO. No, it has to be settled by HO. None of these. Option for question number 61 is none of these. What I told you for nomination, whether the branch is headed by scale 1, scale 2, scale 3, scale 4, scale 5, scale 6, whatever may be the scale, whether it is deposit, whether it is safe custody article or locker, or gold loan, branch has the full powers to settle. So the option is not given here, none of these. Question number 61, none of these. Branch only has to settle. Then your branch is having a deposit account in the name of a minor represented by father as guardian. There is no nomination in the account. Whether for the minor account nomination is possible, sir? So minor account, if it is represented by guardian, nomination is permitted. Who will sign the nomination form? The guardian will sign the nomination form. But minor self-operated account, minors cannot nominate. That the minor can be a nominee, sir? Yes, minor can be a nominee, but minor cannot nominate. Okay, let us see the question. Your branch is having a deposit account in the name of a minor represented by father as guardian. There is no nomination in the account. The minor dies. To whom the money to be given? Father, mother, guardian. You take option number D, you make it none of these. None of these. So to whom you will give the money? When there is a minor account operated by guardian, when there is no nomination for that account, when the minor dies, to whom we give the money? Don't be under the impression when the minor dies, you will give the money to the guardian. Or if his father, if he is guardian, don't be under the impression. When the minor dies, when there is no nomination in that account operated by guardian, the money, the claim settlement will be in the names of the legal heirs of the minor. Then the next question is whether a minor can have a legal heir. Why not? Minor will definitely have a legal heir. Who are all the legal heirs of the minor? The legal heirs of the minor depends upon the religion to which the minor belongs. For example, as per the Hindu law, so for a baby girl, mother is the legal heir. In the case of Hindu law, if it is a baby boy, then both father and mother will have 50% share. They are the legal heirs. Like that, it varies. So don't be under the impression the minor will not have any legal heir. So now the questions are, the account is operated by father, guardian. He only puts the money and he operates. Why we have to give the money to the legal heir? Friends, as once an account is opened in the name of a minor, the father is only a guardian. He operates the account on behalf of the minor since minor is not permitted to operate. So he has opened the account and he is operating the account. He is not the account holder. The account holder is so and so represented by father or guardian. Anybody can deposit money in that account. If the minor dies, the money to be settled in favor of the legal heirs of the minor. Who is the legal heir? It depends upon the religion to which the minor belongs. So question number 62, option D, you make it none of these. So none of this is the answer. So the correct answer is to the legal heirs of the minor. Question number 64. So these things are available in your death claim manual. Question number 63. You come to know the death of a depositor of your branch through his nominee. Depositor's friend is a nominee who comes to the branch to get the money with the death certificate. Who is coming to the branch, sir? The nominee is coming to the branch. At that time, the legal heirs, the family members, along with a high court advocate, also approach you with a plaint they filed in a court, requesting the court to instruct the bank not to give the money to the nominee. So what are here? Who is bringing, sir? The nominee. What I told you. Recollect one of my points in the slide. When there is a nomination, you have to give the money to the nominee only. But there are three exceptions. If a succession certificate is brought by a person, money to be given to the succession certificate holder only. If a probate is brought by a person, money to be given to the probate holder only. If a court order is there, you have to give as per the court order. Here anything is there, sir. You see, nominee comes. Whether you get a court order, no. Only when high court advocate is coming, he is coming and telling these people are the legal heirs. They have filed their suit. Don't worry about filing a suit. The suit may take up or they may not take up. The nominee is there. You have not got either probate, you have not got a succession certificate, you have not got an order restraining you not to make the payment to the nominee. You make the payment. Nominee takes the the money as the trustees of the legal heir. Tomorrow, when the court is going to hear, you go and tell the court, we are settled in favor of the nominee. So court will ask the nominee to give the money to the legal heirs. You don't worry about it. So to whom you have to settle the money, sir? Payment to be made to the nominee. Question number 63, answer is A. Question number 63, answer is A. So this is the last question for test paper number 3. Mr. A has SB account in his name and he nominates his son minor as the nominee for his SB account. Who is having, sir? Mr. A. Who is then, whether minor can be nominee, sir? Yes, minor can be nominee. But minor cannot nominate. Keep that in mind. Mr. A has SB account in his name. He nominates his son, let us assume his son who is a minor. That is as nominee for this SB account. Since nominee is a minor, he has to appoint another person on behalf of the nominee. I told you. If insolvent person is a nominee, another person to be appointed to receive the money. If minor is a nominee, another person to be appointed to receive the nominee. The question is, the major person who has to be appointed, since the minor is the nominee, the major such person who should receive the money on behalf of the nominee should be mother, close blood relative, any person, father. So that is, whenever there is a minor as a nominee to the account, the person who has to be appointed can be any person. It need not be the guardian of the minor. It is a wish of the deposit holder. It is a wish of the deposit holder. Question number 64, answer is C. Question number 64, answer is C. Okay, sir, good. We have covered test paper, 3 papers we have covered. Now let us quickly go through test paper number 4. What is the maximum possible today we will cover? Test paper, no. Test paper number 4 we are going to cover, sir. It's mostly that is legal matters. So questions are few from this paper. So kindly, that is, we are just going to tell answers straight away. Wherever explanation is required, I will explain to you. Okay. Lien is defined in which act? Question number 1. Lien is defined under which act? Lien is defined in Indian Contract Act. See, section 170 and 171 of Indian Contract Act talks about lien. What is that 170 and 171? What is that 170? 170 is general lien. 171 is particular lien. So what is the difference between general lien and particular lien? See, whenever that is, your bank is giving a loan for a account holder. Whenever bank is giving a loan to a account holder, the loan papers will contain a clause. Suppose any security you are giving for this loan, bank has right to hold that security even though you clears the loan if there is another loan. You got my point? So what is a general lien? The general lien is also known as implied pledge. What do you mean by that? So whenever a loan is given against a security given by the borrower, and if let us assume you are given housing loan to a borrower, you are also given a Canara budget loan to the borrower. When you are giving an housing loan, the document will contain, even though you have cleared the housing loan, even though if you clear the housing loan, so we will not release the document till the overdues, if any, in the other loans availed by you will be cleared. So bank will have a general lien for all the securities given by the borrower. For one loan, we will keep it as a security for the other loan also. That is called the general lien. Okay, so particular lien means this loan, this security. That's all. If I clear this loan, you have to release this security. But bankers will have a general lien. Okay, lien is defined under which act? Indian Contract Act. Question number 1, answer is C. Section 170 and 171. So next point, bankers' lien is implied pledge or general lien. Question number 2, I explained to you what is implied pledge is general lien. Securities given for one loan, bank will hold those securities for the other loans of the borrowers, provided the other loans are not that is regular, they are having overdues, etc. That is called general lien. So banker's lien is implied pledge or general lien. Question number 2, answer is A. Question number 3, the right of the banker to adjust the deposit account to the loan account of the same person is called. This question they asked this time from maybe for 2 to 3 or 1 to 2, I don't remember. The right of the banker to adjust the deposit account to the loan account of the same person is called right of set off. That is, he is having a deposit account, he is having a loan account. So whenever there is a loan account is not properly that is settled, properly paid, the bank has the right to adjust the proceeds in the deposit to the loan account of the borrower. So that is called right of set off. Okay. So the right of the banker to adjust the deposit account to the loan account of the same customer is called the right of set off. Question number 3, answer is C. Question number 4. Right of set off is defined in which act? They asked last time. Right of set off is defined in which act? Indian Contract Act, Transfer of Property Act, Negotiable Instrument Act, none of these. Answer for the question is and D. I already given here D. Right of set off is defined in none of these. So right of set off is not defined in any act. It is by practice. It is by bankers' practice. Right of set off is not defined anywhere. So answer is none of this. Question number 5. Right of set off can be used if simultaneous relationship available between banker and customer is dash and dash. See what I told you, when you can make right of set off, he is having a deposit account, he is having a loan account. So you can do right of set off. In deposit account, what is the relationship between banker and customer? In deposit account, bank is the debtor, customer is the creditor. So you have one deposit account. The relationship between bank and the customer is debtor creditor. Then you should also have the loan account. In loan account, what is the relationship between the bank and the customer? Creditor and debtor. So simultaneously, when you have a deposit account, when you have a loan account, you can do right of set off. That means the relationship between bank and customer should be debtor creditor and also creditor debtor. Then only the rate of set off will come, isn't it? Yes. So rate of set off can be used if simultaneous relationship available between the banker and the customer is debtor and creditor and debtor. Question number 5, answer is A. Question number 5, answer is A. They asked once for 3 to 4. Question number 6. There are two firms, please read the question carefully. There are two firms, XY Enterprises and CD Enterprises. XY and CD, partnership firms. Both are having the same partners. AB Enterprises has OD account, so XY, sir, please take instead of AB, please take XY. Okay, so I made it wrongly here, typed as AB. There are two firms, XY and CD Enterprises. Both are having same partners. XY Enterprise, it is not AB, XY. XY Enterprises has OD with your branch, and which is NPA. CD Enterprises is another branch of your bank with current account with credit balance. Can you do write-off set-off in both the accounts? You see, this question they ask, but not in our bank, in some other bank. Now, two partnership account. Both the accounts are in different branches of your bank. In one branch, they are having OD. In another branch, they are having a deposit. Partners are the same. Sir, the rate of set off or lien is for bank as a whole. It is not branch specific, it is bank specific. First point you should know. Whether the deposit is in your branch or the deposit is some other branch, whether the loan is in your branch, you can do rate of set off, no problem, provided the deposit should be in the name of the same individuals. That is very, very important. The loan should be in the name of the same individual. Then only you can do the rate of set off. Now here the question is, there is two partnership firm. So here one XY, another is CD. So as long as the partners are the same, it is constituted as the same individuals. So you can do write-off set-off in whichever branch is there. Since the partners are the same, even though the name of the partnership firms are different, even though the deposit is in one branch and loan is in another branch, you have the right to do this write-off set-off. Question number 6, answer is D. So it can be done. Question number 7, contract contract without consideration is void as per which section of the Indian Contract Act? First you tell me what is contract without void. Contract without void, sorry, contract without consideration is void. For example, let's assume your father-in-law has given you a check for your wedding day. Your father-in-law has given a check for you on your wedding day. You have deposited the check in the account. The check is returned for want of funds in the father-in-law's account. You cannot go to court of law and file suit against him because you got the check not for consideration. What is consideration? So you are selling something, you are getting money. That is called consideration. He has given his daughter to you. That's all. Okay. So the check which you have got is not for consideration. Okay, in such cases, it is not a correct contract. It is a void contract. Void means there is no contract at all. Contract without consideration is void. It is told in which section of the Indian Contract Act, section 25. Question number 7, answer is A. Or they may ask you the question, contract without consideration is void as per section 25 of Dash Act. So then in that case, you have to write the answer as Indian Contract Act. Question number 8. Which is not correct with regard to Right to Information Act. So what is Right to Information Act, sir? So one person is asking a query with an organization. The organization will give a reply to that fellow. That is called a right to information. He has a right to get the information from authorities. Certain information will be given, certain information will not be given. There are various things are there. Now, whenever that is an organization receiving a question from anybody with regard to that is under Right to Information Act. So he has to send a query to that organization with a 10 rupees demand draft. The amount of money required or asking question, getting the reply is 10 rupees. If the printout is more and all, more cost is involved. That and all is different. So you will send a demand draft for 10 rupees asking for certain information from the bank. Let's assume from Canara Bank is asking for some information, asking for Canara Bank. Under the Right to Information, the reply can be given, reply will be given, otherwise the reply will not be given. Okay, they will say reply will not be given. Now, within how many days of getting the query under the Right to Information Act, the reply to be given? So the reply has to be given within 30 days normally. Suppose if the question is related to the life of the person. So let's assume you are getting a query question from the jail authorities. Tomorrow or day after tomorrow or next week, we are going to hang so and so. We want to know whether deposit of this fellow is with you. So whenever the life of a person is at threat, when a question is asked regarding that person, the reply has to be given within 48 hours. So normally the reply has to be given within 30 days. If the life of a person is at threat or jeopardized, then you have to give reply within 48 hours. If the reply is not given within the scheduled time of either 30 days or 48 hours, the fine the bank has to pay is 250 rupees per day, maximum 25,000 rupees. Okay. And then one more point, whenever a person is asking a query under Right to Information Act, he need not give the reason for which he is asking the query. Again, I repeat, Right to Information Act, whenever you are getting a query, within 30 days, the reply to be given. If the query is with regard to the life threat of a person, then reply has to be given within 48 hours. If the reply is not given within the scheduled time, the penalty is 250 rupees per day, maximum 25,000 rupees. And when a person is asking a query under Right to Information Act, he need not give the reason for which he is asking the query. Now let us see which is not correct with regard to Right to Information Act. Reply to be given 30 days. Yes, that is correct. If the query is with regard to life of a person, reply to be given 48 hours. That is also correct. A person asking the query has to give the reason for asking the query. That is not correct. So question number 8, answer is, which is not correct, answer is C. Question number 9. Safe custody article is covered under which act? Safe custody article. I told you, we talked about safe custody article, nomination, etc. Safe custody article is covered under which act? So Indian Contract Act. Question number 9, and simply straight away you take the answer. Question number 9, answer is C. Question number 10, contract of insurance. Contract of insurance, sorry. Contract of insurance is a contract of indemnity, utmost faith, good faith, fair faith. Our options are 1, B2, C1 and 2, D1 to 4 all. So contract of insurance is a contract of indemnity or contract of utmost faith. So both 1 is correct and 2 is also correct. Your option is C. Question number 10, your option is C because it is contract of insurance, is contract of indemnity. It is also contract of utmost faith. 1 and 2. Question number 10, answer is C. Question number 11. When a court appoints a guardian for a minor, he attains majority at the age of 21 years, 18 years, either A or B, neither A or B. See, a minor is, there are how many types of minors are there, sir? So, how many types of guardians are there? Sorry, not minors, guardians. How many types of guardians are there? Natural guardian, then testamentary guardian, then legal guardian. Who is the natural guardian? In the case of Hindu law, father is the natural guardian. If he's not, then mother will form the natural guardian. Like that, Muslim, Christians, etc., various religions are there. So they are called the natural guardian. If natural guardian is not there, then we are having another guardian called the testamentary guardian. In the will of the natural guardian, if they have written after our period, so and so will be the guardian for my minor son or minor girl. So the person named in the will as guardian is called testamentary guardian. I told you testate means right, will. Testamentary guardian. The name of the person mentioned in the will is called testamentary guardian. Then, if there is no testamentary guardian, somebody will approach court for this minor boy, we want a legal guardian. Court will appoint a guardian. That guardian is called a legal guardian. So, how many guardians are there? Natural guardian, testamentary guardian, then legal guardian or court appointed guardian, you can say. So, whatever may be the types of guardian, the minor attains majority when he completes 18 years. Keep that in mind. Earlier, as per the Indian Majority Act, when there is a legal guardian for a minor, he will attain majority when he completes 21 years. That is changed now. So whatever may be the type of guardian, minor attains majority when he completes 18 years of age. Question number 11, answer is B. Question number 11, answer is B. So here we saw some more. No, what are the things we saw? Natural guardian, then we got testamentary guardian, then we got also legal guardian or court appointed guardian. See, we are not just going through the question, we are going through the probable type of other questions that will be asked in the exam from these questions also. Okay, sir. Question number 12. Question number 11, answer is B. Question number 12. A minor attained majority on 1st April 2021. Check signed by his guardian, that is his father, dated 25th March 2021. Before the minor, he attained a majority on 1st April. On 25th March itself, the guardian has issued the check. Issued in favor of the college where he studies, comes for payment on 31st May 2021. So when the check is issued, sir, 25th March. When the check comes for payment to you, 31st May. When the minor attained majority on 1st April. Okay, sir. Now the check has come. Check was issued before the minor attains majority, and the check comes to you for payment after the minor attains majority. And one more point: the check is for favoring the school fees. Whether you have to pass the check or you have to return the check. What the law says? The law says, once the minor attains majority, any debit in the account of that fellow, that is who is major now. Earlier he was minor. Again, I repeat. When a minor attains majority, any debit in the account of this major who was earlier minor is only, that is with the consent of the major. So the check is issued by the guardian. So the check comes for payment after the minor attains majority. You should not debit that person's account because once the minor attains majority, that is, you have no right to pass the check issued by the guardian, even though it is dated before the minor attains majority, whatever may be the purpose. Okay, pass the check as it is for the college fees. Return, discretion of the bank, none of these. Return the check. Question number 12, answer is B. Then What type of guardian a mother can be in respect of a Muslim minor girl? Sir, I told you in the case of there is with regard to guardian, as per the religion Hindus, it is father is the guardian, when natural guardian. When father is not there, then mother will be the natural guardian. So in some cases, even though when father is there, due to various reasons, mother also can be natural guardian as far as the Hindu law. Coming to Muslim law, who will be the guardians? Natural guardian. First, father will be the natural guardian. If father is not there, the will of the father, if the father has written any will, the person mentioned in the will be the guardian for the child. First, I will tell you, we are talking about Muslim law. When father is there, he will be the natural guardian. If he is not there, the person mentioned in the will of the father is the natural guardian. If the father has not mentioned anybody's name in the will, then father's father will be the natural guardian. Okay, third person. So after father's father, who will be the natural guardian? After father's father, the person mentioned by the father's father in his will be the guardian. Again, I repeat. So for a Muslim boy or girl, father will be the natural guardian. If he is not there, then so if he has written a will, the next guardian will be, if he has written a will, the person mentioned in the will be the guardian. If he has not written the will, father's father, if he is alive, he will be the guardian. So if the father's father after his death, if he has written somebody in his will, then he will be the guardian. Suppose if there is no will of the father's father, then court will appoint somebody as the guardian. Now the question is whether at any point of time mother can be the guardian. So mother cannot be a natural guardian at all for a Muslim girl, minor girl or boy. Mother cannot be a natural guardian, but she can be a guardian, either testamentary guardian. Suppose if the father has written in his will, after my death, my wife should be the guardian of the child, then father's father will not enter into picture. So she can be a testamentary guardian. Suppose if the father's father has written a will, he says, after my death, my daughter-in-law, that is mother of this boy will be the guardian. Then in both the cases, she can be a testamentary guardian. If, no, if not that, suppose if the court appoints the mother as the legal guardian, she can be a guardian. You got my point? So as per Muslim religion, mother cannot be a natural guardian, but she can be a testamentary guardian and she can be a legal guardian. What type of guardian mother can be in respect of a Muslim minor girl? Mother cannot be a guardian at all. Natural guardian, legal guardian, testamentary guardian. So 3 and 4. So where 3 and 4? Where question number 13, answer is C. Question number 13, answer is C. Question number 14. A person who writes a will. A person who writes, I told you, when so the will is testate. So a person who writes a will is called testator. A person who writes a will is called testator. All one mark questions. You should not miss it. A person who writes a will is called testator. Testamentary disposition. We saw, no, like that. When a person dies testate, the succession appointed by the will is called. What do you mean by when a person dies testate? When a person dies testate means he has died after writing the will. Okay, please keep it in mind. When a person dies testate means he has died after writing the will. So he has written a will and he has mentioned a person in the will who will be the succession for me. Okay, he is the person, he is mentioned in the name of the person. So the name of the person mentioned in the will is called executor. Please remember, friends, a person who has written the will is called testator. Then when a person dies testate, means he has written a will and he has died. When a person dies testate, the succession appointed by the will, succession means after this fellow, he should be my property owner. So the succession appointed by the will is called executor. Okay. So find question number 14, question number 15, question number 14, answer is D. Question number 15, answer is A. Question number 16. Will certified by the court. Several times I told you, a will certified by the court is called probate. Question number 16, answer is D. Will certified by the court is called probate. Question number 17. When a person dies intestate. Here you see question number 15, you see, sir. When a person dies testate, that means what? He has written a will and died. So he is a testator. Okay. When a person dies intestate, he has not written any will. Yes, huge property is having. No nomination, is not made any will. Okay, when a person dies intestate, dash can appoint a person or persons to look after the properties of the deceased by a letter of. So let's assume a person has a huge property, he has died. So then somebody approaches somebody. So a person, when he dies intestate without writing a will, then who can appoint somebody to look after the assets of the deceased person? When a person dies intestate, question number 17, court can appoint a person or persons. Court can appoint a person or persons to look after the properties of a deceased person by means of a letter of administration. Again, I repeat, when a person dies testate, that is when he dies by writing a will, the person or persons named in the will are called executors. When a person dies intestate, that are without writing a will, then who will appoint successor? The court will appoint a successor. By what? The court will issue a letter called letter of administration. Okay. When a person, question number 17, when a person dies intestate, court can appoint a person or persons to look after the properties of the deceased by a letter of, that is, administration. When you want to open a bank account for the executor, when you want to open, who is an executor? The person named in the will. Who is that is when you want to open a, for example, so that is when you want to open an account for a will, then the will should be got certified by the court. Similarly, when there is no will, court will appoint a letter of administration. The person mentioned in the letter of administration is called administrator. Who is executor? The person mentioned in the will is called the executor. Who is administrator? Persons mentioned in the letter of administration are called administrators. If you want to open an account based on a will, so it should be probate. You should got certified by the court. Similarly, if you want to open an account, if you want to open an account for executors, you should get copy of probate. If you want to open an account for administrators, you should get letter of administration. Then you open the account. To question number 18, to open executor's account, banks insist for executor's account. Banks insist for probate. What is probate? Will certified by the court. Who is an executor? Person named in the will is the executor. To open executor's account, banks insist for probate. To open administrator's account, banks ask for letter of administration. Okay, 19. Executors and administrators are appointed as per which act? So that is, there we saw missing person is defined in Indian Evidence Act. Missing person is defined under Indian Evidence Act. Here, executors and administrators are appointed as per Indian Succession Act. Question number 19, answer is A. Question number 19, answer is A. Question number 20. An executor or administrator can appoint an agent. See, that suppose we have the power of attorney holder, isn't it? Or mandate holder. Where account holder is there, he gives the power of somebody to operate the account. So he is called the mandate holder, or he is the agent for the principal. Whether, so there is an executor. There is a will in that some executors are there. There is a letter of administration in that administrators are there. So they cannot delegate their authority. Executors and administrators cannot delegate their authorities. If there are more than one executor, all of them have to operate the account jointly. If there are more than one administrator, all of them have to operate the account jointly. There is no question of either or survivor, number one or survivor, etc. Again, I repeat, if there are more than one executors, all executors have to join together and operate the account. If more than one administrators are there, all of them to join and operate the account. Executors and administrators cannot delegate their authority to somebody else. So on the other hand, either any one of the executor or any one of the administrator can use stop payment instruction. So to issue a check, all executors to join. To issue a check, all administrators have to join. But to make a stop payment, any one of them to give the stop payment, you have to accept the stop payment. Okay, so similarly, executors and administrators cannot appoint agents. They cannot make attorneys to operate that account. Okay, so question number 20. An executor and administrator can appoint an agent. False. They cannot appoint an agent. Question number 20, answer is false. Question number 21. Executors and administrators are the trustees for the legal heir. No, nominees are the trustees for the legal heir. Similarly, executors and administrators are the trustees for the legal heir. Then, when there are more than one executor or administrator for an account, what should be the operation condition of the account? Based on the mandate of the will or letter of administration, severally, former or survivor, jointly. So whenever there is more than one executor, more than one administrator, all of them to jointly operate the account only. Question number 22, answer is D. Question number 23. Instructions for stop payment of a check can be given by any one executor or administrator when there are more than one executor and administrator for an account, which is correct with regard to this statement. Both to give since the account to be operated jointly. Statement is correct. Based on the will or letter of administration, none of this. What is the statement, sir? Instructions for stop payment of a check can be given by any one of the executor or administrator. So statement is correct. So this question they asked for some other bank last time. Question number 23, answer is B. So when there are more than one executor or administrator, both have to sign the check. When there are more than one executor or administrator, any one of them can use stop payment instruction. Question number 23, answer is B. Question number 23, answer is B. Question number 24. An executor or administrator can, sorry, again it is repeated, sir. So they cannot appoint, it is false. Okay. Question number 25. Karta in HUF can delegate the authority to operate the account too. What is Hindu and divided family? So Hindus, then Jains and Sikhs. Hindus, Jains and Sikhs, they can form Hindu and divided family. So that is all those things, let us not worry about it now. Now, whether in the senior most co-parcener, so there are all the family members are called co-parceners. The senior most co-parcener, whether he is a male or female, earlier females cannot be, now either male or female, the senior most co-parcener in HUF will be the Karta. He will be operating the account. Okay. Karta in HUF can delegate the authority to operate the account. Whether he can appoint an agent, or he can appoint a co-parcener to operate the account, or he only has to operate the account. That is the question. So Karta in HUF can delegate the authority to anybody. He can give to other than the co-parcener also to operate the account, or he can give the power to senior most co-parcener, or he can give the power to any co-parcener. It is his right. Okay. Karta in HUF can delegate the authority to operate the account. A. One or more co-parceners. Delegate to third party. Only to senior most co-parcener. No. Karta cannot delegate. No. So he can delegate to one or more co-parceners, or he can give to third party. So A and B both are correct. Question number 25, answer is E. Question number 25, answer is E. These are all the legal aspects, so you can expect in the exam. When the Karta expires, the money in the SB account to be given to all co-parceners, legal heirs of Karta, nominee if there is nomination, senior most co-parcener who becomes Karta. See, in the case of an HUF account, So there cannot be any nomination, is it? The HUF account cannot nominate. So where is the question of legal? No, all those things are not there. When the Karta dies, the senior most Karta will take charge. There is no question of death claim settlement for an HUF account. Friends, please keep in mind, there is no concept called death claim settlement or nomination settlement for a HUF account. When the Karta dies, the senior most co-partner will become the Karta and he will operate the account. He can close and take the money. Got my point? Okay. So when the Karta expires, the money in the SB account has to be given to senior most co-partner who becomes the Karta. So question number 26, answer is A. Question number 26, answer is A. Question number 27, Mr. A sole trustee of the trust account died. Check issued by him comes for payment. Return, pass, discretion of the bank, none of these. Whenever there is a sole trustee, only one trustee is there. When he dies, there is a plain question. They are not given the check dated, check signed date, when the check comes for payment, nothing they are told. So the question is, so there are two things. So sole trustee and more than one trustee. Okay, now we are seeing for sole trustee. When there is only one trustee, checks signed by him comes for payment. So no date, nothing is mentioned. Pass the check. If he is a single trustee, even if he comes to know that he has died, you can pass the check. Okay, question number 27, pass. On the other hand, question number 28, you see, Mr. A sole trustee died on 25th April. A check dated 10th April signed by him comes for payment on 2nd May. So that is Mr. A sole trustee that is died on 25th April. The check is dated 10th April signed by him comes for payment. Question number 28. 1 minute, sir. Question number 28. Okay, comes for payment. So here, if they are given the date, indicate. So we are talking about sole trustee, only one trustee. Sole trustee, he dies, so check comes for payment, pass. That's all, very clear. Suppose in the same question they are given the date of the check and when it comes for payment. So sole trustee account, when they give the date of the check and when they are given the date of death of the trustee and then they are given when it has come for payment, you have to see all the 3 dates. I tell the logic, then you tell the answer. In the case of a sole trustee account, checks dated before the date of his death. In the case of a sole trustee account, checks dated before the date of his death comes for payment after the date of his death. If all other things are in order, you can pass the check. Again, I repeat. In the case of a sole trustee account, checks dated before the date of his death. When it comes for payment after the date of after his death, it can be passed. On the other hand, in the case of a sole trustee account, checks dated after the date of his death. When it comes after the date of his death, you cannot pass the check. Okay, there is a logic. So, Mr. A sole trustee died on 25th April. A check date, so the date of the check is before the date of his death. Okay, signed by him, comes for payment on 2nd May. He died on 25th April. The check dated is before the date of his death. You can pass the check. Question number 28, answer is A. Question number 28, answer is Raghavan. Later. Question number 28, answer is A. Question number 29. So this is more than one trustee. When one trustee dies, what you have to do? So in the case of a more than one trustee account, whatever may be the operation condition in the account, when there are more than one trustee in the account, when one of the trustees is died, you have to take the trust deed and verify. After the death of one of the trustee, what it is mentioned in the trust deed. So the operation condition may be anything that is mentioned in the trust deed. But suppose if one of the trustee dies, whether you can pass the check or what has to be done to the trust, that you have to see the trust deed. If the trust deed is silent about it, then the people have to approach the court and get a revised trust deed. Again, I repeat, in the case of more than one trustee, after the death of one of the trustees, whether the surviving trustees can operate the account, that depends upon what it is mentioned in the trust deed after the death. If the trust deed is silent about it, then people have to approach the court and get the revised trust deed. Then you have to permit operation. Okay, sir. Now let us see the question. There are two trustees in an account. The operation condition in the account is any one trustee can operate. Operation condition, any one trustee can operate. But after the death of the trustee, who has to operate, that you have to see in the trust deed. If that is silent about it, then people have to approach the court and get a revised trust deed. Till then, you will not permit any operation. There are two trustees in an account. The operation conditions in the account is any one trustee can operate the account. You got the information that one of the trustees died. Trust deed to be verified for allowing further operations in the account. Check signed by the surviving trustee can be passed. The author of the trust to be contacted. None of these. The answer is question number 29. Answer is, I told you the reason. Answer is A. Question number 30. Your branch receives a letter from Mr. A, the sole trustee of your trust account, authorizing Mr. B to operate the account during his absence out of India. What you will do? Accept only if it is notarized, accept only if it is registered, none of these. See, a trustee, like your so like executors and administrators, a trustee cannot nominate. So sorry, a trustee cannot delegate his authority. He is already gotten power, isn't it, by somebody. From the trustee, he has the power to operate the account. A trustee cannot delegate his authority. So your branch receives a letter from A, the sole trustee of the trust account, authorizing him to operate the account in the absence of India. So accept. That is accept only if it is notarized, accept only if it is registered, none of these. Don't accept, because a trustee cannot delegate. Question number 31. Your branch receives a check issued by a trustee on the trust account. An important question, maybe for higher levels. Anyhow, you can also understand that, because this question was asked for 3 to 4 once. Your branch receives a check issued by a trustee on the trust account. You come to know that he has become insolvent. He has declared insolvent by the court. The check has to be passed if all other things are in order. For the reason, trustee is alive, balance is available in the account, it is a check issued on the trust property, none of these. Friends, here I want to tell you. See, forget about the trust account. You are having an account of an individual. You are having an account of the individual. So you got a court order that the individual has been declared as insolvent. Once a person has been declared as insolvent, then the court will appoint a person to manage the assets. The person appointed by the court is called official receiver or official assignee. So we are not talking about the trust account now. We are talking about individual account. Then I will come to the trust account. When an individual becomes insolvent, insolvency certificate will be issued by the court. So he will go and file in the court. Sir, I have become insolvent. I cannot do anything. I have a lot of debts. So do something about it. Then court will declare him as insolvent, and a certificate will be issued by the court, and a person will be appointed to manage the debts of this fellow. The person appointed by the court is called official receiver or official assignee. Once a person is declared as insolvent by a court, then further operations in the account, and if you come to know that, further operations in the account should not be permitted, because it is a right of the official assignee or official receiver to operate the account. But so that is that you have to stop, like the death of the customer, you have to stop. But in the case of a trust account, so you got a check in the check issued for the trust. The trustee becomes insolvent. So even though the trustee becomes insolvent, checks issued by him to be passed, because insolvency of a trustee will not affect the trust property. They asked this question for 3 to 4. Insolvency of a trustee will not affect the trust property. If it is personal account, you will not pass. It is a trust account, then you can pass the check. So question number 31. It is a check on the trust property. Your branch receives a check issued by a trust on the trust account. You come to know that he has become insolvent. This check has to be passed if all other things are in order. For the reason, it is a check on the trust property. Question number 31, answer is C. Question number 31, answer is C. Question number 32, whether a minor or insolvent person can be agent. Okay, whether a minor can be a nominee, sir? Yes. Whether insolvent person can be a nominee, sir? Yes. Okay, whether a minor can nominate, sir? No. Whether insolvent person can nominate, sir? No. Similarly, a minor or insolvent person cannot appoint an agent. Again, I repeat, a minor or insolvent person cannot appoint an agent, but they can be agents. Again, I repeat, a minor or insolvent person cannot appoint agents, but they can be agents. Whether a minor or insolvent person can be an agent, yes, they can be agents. Then, Mr. A, the account holder, has appointed Mr. X as agent to operate the account. Please read the question. These questions are frequently asked by IBBS in the promotion exam. Mr. A, the account holder, has appointed Mr. X as agent to operate the account. Branch got the information that Mr. X died. Who has died, sir? Agent has died. Agent has died. All other things are in order. Meanwhile, a check signed by Mr. X is presented for payment. Return, pass, get confirmation from Mr. A, the account holder, and pass, discretion of the bank. Here, though the question is plain, again, they are not mentioned any date of the checks, etc. So, when nothing is mentioned about the date of the check, death, etc., you have to see, so who has issued the check, who is alive, who has died. As long as the principal, as long as your account holder is alive and all other things are in order. All other things means what, sir? Account is there, balance in the account is there, date of the check, no problem, everything is pakka. That is called all other things in order. As long as your account holder is alive, when all other things in order, even though the agent has died who has issued the check, you can pass the check. So that is the question is a check. That is question number 33. Mr. A, the account holder, has appointed Mr. X as the agent to operate the account. Branch got the information that Mr. X died. X is the agent. All other things are in order. Meanwhile, a check signed by Mr. X is presented for payment. Pass the check. Question number 33, answer is B. Question number 34. Here, the same question is given, but with a date. So in that case only, you have to see when the agent died and what is the date of the check and when the check is presented. You got my point. So the question number 33, plain check. Agent died, check comes for payment. Whether you will pay, yes, you will make payment. All other, because the account holder is alive. In the second case also, question number 34, also agent has died. Whether you will pass it or not, that depends upon what is the date of the check. Question number 34. A check signed by an agent, the date of the check is 10th April. The agent died on 1st April. So the date of the check is 10th April. The agent died on 1st April. That is, before his death, he has issued a post-dated check. Isn't it? That is called. So he has died on 1st April. Maybe before his death, he has issued a post-dated check. Question number 34. 1 minute, sir. Question number 34. Question number 34. Okay. So a check signed by an agent. The date of the check is 10th April. The agent died on 1st April. The check comes for payment on 12th April. So he has died on 1st April, no, after his death. Will you pass? See, whenever the date is given, when an agent, the check signed by the agent has died. If the date of the check is subsequent to the date of his death, again I repeat, if the date of the check is subsequent to the date of the death of the agent, that check should not be passed. On the other hand, if the date of the check is before the date of the death of the agent, then the check can be signed. Okay, can be passed. The check is signed by the agent. The date of the check is 10th April. The agent died on 1st April. The check comes for payment on 12th April. Will you pass? What is the date of the check, sir? 10th April. When he has died, sir, 1st April. The date of the check is subsequent to the date of the death of the agent, so don't pass. Don't pass. First question is don't pass. No. On the other hand, if the check is dated 30th March, will you pass? Yes, you will pass because the check dated is 30th March, but he has died on 1st April. Then in the second check can be passed. If the date of the check is 30th March, you can pass the check. That is a logic. So in question number 33, so in both the questions, who has died is the agent has died. In both the questions, the agent has died, all other things in order. That means the principal is alive and all other things are pakka. So in question number 33, they are not given any date of the check, etc. Close your eyes and say, if the agent died, if the principal is alive, you pass the check. Coming to question number 34, when the date is given, you compare the date and date of the check and date of his death, accordingly take a call. Then question number 35, you see. A check is issued by an agent, comes for payment. So agent has signed the check. Agent has signed the check. You come to know that the principal died. So you come to know the principal has died. Pass the check as signatory is alive. Return as principal is died. Get confirmation from legal heirs of principal and pass. None of these. Sir, once you come to know something has happened to your account holder, like he has died, he has become insolvent or he has become insane. Once you come to know that something has happened to your account holder, whether the check is signed by your account holder or by his agent, and the date of the check, nothing you should see. Once you come to know that something has happened to your account holder, you need not see what is the date of the check, what has been, when he has died, etc., etc. Whomsoever has signed the check, either agent or his account holder, whomsoever has signed, whatever may be the date of the check, once you come to know the agent principal has died or principal has become insolvent or principal has become insane, you have to return the instrument. Okay, let's see the question number 35. A check issued by an agent comes for payment. You come to know that the principal died. Who has died? Principal has died. That's all. Close the account. Pass as the signatory is alive. Return as the principal is died. Question number 35. Answer is B. Question number 36, you see. These are all the 4 questions. Repeatedly, they are asking. So, logic you should know. You can tick the correct answer. Question number 36. A check issued by the agent comes for payment. The principal died. The date of the check is 1st November 2019 and the date of death is 8th November. What to be done? Pass the check or return the check? Friends, I told you, you have to see what has happened to the principal. So you come to know that the principal has died. There is nothing. Once you come to know that something happened to the principal, don't see who has signed the check, whether he has signed or agent has signed, what is the date of the check, etc. Return the instrument. So question number 36, answer is return the check. Question number 37. SB account in the name of A and B with operation condition severally. What do you mean by that? So either or survivor. Any one of them can operate. That is called, so for operative accounts, it is operation severally. For term deposit accounts, it is payment either or survivor. Please keep in mind. So for operative accounts, either or survivor means operation severally. Any one of them can operate. For fixed deposit accounts, either or survivor means so payment to be made to any one of them on maturity. There is a difference between the two. Okay. SB account in the name of A and B with operation condition severally. Check signed by Mr. A. Some alter this question they asked year before last. Some alterations are made in the check or authenticated by Mr. B. So what has happened? Who has issued the check? So what is operation condition severally? Any one of them can operate the account. So who has issued signed the check? Mr. A. So let's assume A has issued the check, operation either or survivor, any one of them can sign the check. A has signed the check, amount for 1 lakh. Subsequently, the check amount has become 10 lakhs. Somebody has made it 10 lakhs. The authentications are made by B. Let's assume A is not in station. So A has issued the check for 1 lakh. Some alterations have been made. The 1 lakh has become 10 lakhs. But A has signed the check. So because operation is severally, then alterations 1 lakh has become 10 lakhs, and the alterations are made by B. B is also permitted to operate the account. The check comes for payment. Whether you will pass because operation condition is severally or what you will do. Friends, here the logic is the operation condition is severally is only to sign the check. So either A can sign or B can sign. If there is, suppose let's assume A has signed, if there is any alterations in the check, and the alterations has to be confirmed by the person who has signed the check. There is a logic. So operation is either or survivor, sorry, severally. So anyone can sign the check. So alterations, so but here the alterations are made by B. So it should have been made by A. In such a situation, you have to get the confirmation of Mr. A, then you have to pass the check. So SB account in the name of A and B with operation severally. Check signed by Mr. A. Some alterations made in the check are authenticated by B. Our options are pass since operation condition is severally, return, get consent of A and pass. So question number 37, answer is C. Question number 37, you have to get the consent of Mr. A and then you have to pass. Similarly, locker is C. So we'll see up to question number 40 and wind up today. Okay, with regard to PAN, two questions there is two questions are there PAN. With that, we'll wind up today's class. So maybe 41 or 42. Okay. So question number 38. Locker is operated either or survivor. A reports key is lost. Locker is operated either or survivor. A comes and gives a letter. Any one of them can operate. A comes and gives a letter to you that the key is lost. After A has left, B comes with you with the key to operate the locker. So what is operation condition? Either or any one of them can operate. But you got a letter from Mr. A that the locker is key is lost. So now it should give some suspicious to you. B is coming to operate the locker. B is coming to operate the locker. You can permit B with the consent of A only. You can permit B with the consent of A only. So permit since operation either or survivor, do not permit with the consent of A. Question number 38, answer is C. Question number 38, answer is C. Question number 39. Aadhaar has how many numerals? Aadhaar has how many numerals? Question number 39. So Aadhaar has how many numerals? So I need not tell you that is 12, 10, 8 other than the option. Numeral alpha is only, sorry, an Aadhaar has how many alpha numerals? Answer is none of the other than the option because Aadhaar is having 12 numerals. It is not alpha numeral, isn't it? So the option is not 12. Your correct option is other than the option. Similarly, PAN is having 10 alpha numerals. PAN is, last time they asked this question for clerical officer. So PAN is having 10 alpha numerals, whereas Aadhaar is having 12 numerals. So here the question is, Aadhaar is having how many alpha numerals other than the option? So question number 40, 41, we'll finish up this. Question number 40, 41, we'll finish up with regard to PAN. Then we'll see the other things tomorrow. PAN contains 10-digit alphanumeric, isn't it? So my PAN number is AADPJ4647D. AADPJ4647D. That is my PAN number. Okay. So PAN contains, so you also note down your PAN number if you know that by heart. PAN contains 10-digit alphanumeric. If the fourth letter in PAN is P, it is issued to. What is my PAN number? I told you, always the first 5 letters will be alpha. Okay, AADPJ. First 5 letters will be alpha. Then next 4 letters will be numeric. Then the last number again will be alpha. Again, I repeat, in a PAN, 10-digit alpha numeric. First 5 digits will be alphabets. Next 4 digits will be numeric. The last digit again will be alphabet. So my PAN number is AADPJ. So AADPJ, my fourth letter in my PAN number is AADP. So AADP. Individuals, your PAN number also AAD, so some number P has to come. In all the individuals PAN number, the fourth letter will be P only. You can refer. In all the individuals PAN number, the fourth number will be P. So when you see in a PAN number, the fourth alphabet as P, it is issued to individuals. It is issued to individuals. If you see the fourth alphabet as C, it is issued to a company. If you see the fourth alphabet as H, it is issued to a HUF. You got my point? If you see the fourth alphabet as A, it is issued to associate of persons. If you see the fourth alphabet as T, it is issued to a trust. So if they ask the question, you should not miss. The fourth alphabet denotes to whom the PAN card is issued. For all the individuals, the fourth alphabet will be P only. P means the PAN card is issued to an individual. Okay, question number 40. PAN contains 10-digit alphanumeric. If the fourth letter of PAN is P, it is issued to an individual. Okay, sir. Question number 40, answer is A. Okay, sir. Now that is time, it's 9 o'clock. So with that, we'll wind up the session today. The next session, when the organizers is announced, we will meet. Till then, good night. Thank you very much for your patience here.